House.
The Honourable David Parker.
Thank you, Mr. Speaker. Can I thank the last speaker for his contribution? I just want to elaborate on something that the last speaker averted to. One of the submissions that was made in respect of the drug and alcohol testing of people who are on bail was made by the Law Society, who said that it ought not to be in the power of registrars to impose a drug and alcohol condition as a condition of bail if the defendant didn't agree to it, and that that sort of imposition on the person who was being seeking or being granted bail should be left to a judicial officer. And the Select Committee agreed with that, and it has proposed an amendment which says that a registrar must not impose a drug or alcohol condition unless the defendant consents to that condition being imposed. And that effectively means that if the defendant doesn't agree, says it's not appropriate, then it's up to a judge to make a decision as to whether it's an appropriate condition to be imposed. I think that's a wise change, sir. I don't think we should remember that people who are on bail have not yet been convicted of an offence. Sometimes they're innocent, and they certainly haven't had their guilt proved. And so they're in a slightly different situation to someone who has already been convicted and is within the justice system, and the justice system can impose more, or there's more justification for imposing these sorts of conditions against the will of the person concerned if their guilt's already been proven. So I think it's appropriate that in respect of bail decisions, the registrar shouldn't be able to impose a drug or alcohol condition unless the defendant consents to the condition being imposed. That doesn't mean to say that it won't be imposed. It doesn't mean to say that it shouldn't be imposed. It does mean that sometimes it shouldn't be imposed, and where the line is to be drawn between those that should or shouldn't have those conditions is appropriately a decision for the judge rather than a registrar. Sir, the other concern that the Law Society raised was that continuous monitoring obligations, in their view, amounted to an infringement, a major infringement of liberty, which breached the rules. And they said that it seemed wrong for police and corrections to be writing the rules that allow themselves to blood test people who aren't even in prison. So they could be on a community-based sentence, and they thought that it was wrong that the police and corrections officers were the ones who were empowered by law to write the rules about testing in the community, given that they're the ones that are going to be applying them. And they thought that that duality of roles was wrong. The then Minister of the Minister of Corrections at the time, Sam Lochroinga, said that the principles were included in the bill to guide officials in setting up the drug testing regime, and these included a requirement that the testing could not be unreasonably intrusive or frequent, and that the person who's being monitored should be given as much privacy and dignity as possible. That's an issue that we can delve into more at the committee stage of this bill, sir. And if I'm in the House at the time, I will be asking that question. The Law Society went further and said that they didn't think that any person should be required to wear an alcohol monitoring bracelet without judge's approval, because the bill as it stands in respect of someone who's previously had a conviction puts that decision in the hands of the police and corrections officials. And again, we'll be asking the Minister to justify why that's...
A point of order, come on, sing back.
I think we should remind the member this is the third reading of the bill.
Yes, yeah, that's not the member's role, and he is, you know, I mean, he's the least likely member to be warned for being disorderly, but actually it is disorderly.
No, actually, sir, I think that was a fair comment. I'll defend the member for saying that. So
If he was looking and not reading, it would have been easier.
well, it was certainly a less rude gesture than if you'd been indicating a second reading, sir. So thank you for that. Thank you for that assistance, sir. I accept what the member who's just made that point of order said in his contribution to this debate, that issue had been covered off by the Select Committee, and that he was satisfied, and so were the other members of this House, that the concerns of the Law Society were appropriately dealt with in the protections that are found in the legislation as to principles. And I'm not going to be able to inquire that about committee stage because it's already passed. So, Mr. Speaker, the Labor Party is supporting these bills because I think most people in society would agree that for some people who have alcohol and drug problems, it is necessary for both their own protection and the protection of the community that we have some forms of intervention that, as people are transitioning from a custodial sentence back into society, that they are encouraged to stay drug and alcohol free. I would note that monitoring is only part of the solution, and that the Police Association said that in order for these things to be effective, you actually have to have the drug and alcohol treatment courses that are available to people who have come out of custodial sentences. Sadly, a lot of them won't have had those treatment services available to them while they were in prison, because those services are still not broadly enough available. It's also true that some people, whilst in prison, may not be willing participants in them, but once they get out into the community might have changed their mind and recognise that they need help with their drug and alcohol addictions, and that they should have services that are available to them for their own betterment and for the protection of society. And it is a sad reality that one of the reasons, and it's only one of the reasons why we have an increasing prison population in New Zealand, is that we actually haven't got those services under control yet in New Zealand. We have large numbers of our prison population suffering from drug and alcohol problems, which, as my colleague Kelvin Davis has already said, is a contributing factor to their offending. He doesn't present it as an excuse for their offending, he just states it as a fact that it is true that that people who have drug and alcohol problems who are more likely to offend, and that is ameliorated if they have the ability to deal with their drug and alcohol addictions through services that are available. Of course, a lot of the people who are affected are it's true also that disproportionately the number of people who are in prison also have other problems. Some of them are very, very poor. Some of them have psychiatric problems as well. A lot of the people who are in need of these services to deal with their drug and alcohol problems are least able to afford to pay for them, and if they are not provided by the government at low cost or free, they won't be accessed by them, and that's one of the reasons why it's important that we as taxpayers and we in this House support the provision of those services in the community so that the drug and alcohol problems of people who have offended can be dealt with. Sir, I don't think I've got anything other than to say than that. There are three parts to this, really. That's the people who are on parole, people who are on bail, and people who have had community-based sentences are all affected by this legislation. And so long as there are appropriate safeguards, this should work okay. I think it is, if those that have these powers overuse them and use drug and alcohol testing to an excessive degree and it becomes oppressive, then it actually won't meet its social purpose of helping people to overcome their problems. In fact, it could have the opposite effect, and it could amount to a post-sentence infringement of their liberties if taken too far. So I trust that the authorities will be cognizant of that, and I hope that these pieces of legislation work to improve outcomes for our society. The Labor Party supports these bills.